In this lecture, we would like to discuss about the realistic school of jurisprudence. So, the very realist school of jurisprudence had its origin and development in United States of America. So, the American school of realistic jurisprudence is otherwise known as rule skeptic. So this is also called as the left wing of sociological jurisprudence. The very emergence of realism in jurisprudence is the study of law as it works and functions, and it contributed to the growth of skepticism towards law and its administration, and accordingly subjected law to realities of social life. So Gray laid on the importance of the functional and the working of law. So, in his very work, The Nature and Sources of Law, he lays that a skeptical approach towards statute law and the legislation, and it is Justice Holmes who is truly described as the spiritual father of modern legal realism. It is Justice Holmes who openly raised the banner of revolt and doubt against the existing belief of legal certainty and conceptualism. So, the very question that was raised, it could be traced to that they borrowed to some extent the ideas of realistic jurisprudence from the sociological school of jurisprudence. So the modern realistic jurisprudence can otherwise be described as the left wing of sociological jurisprudence. So it was better enunciated by Justice Holmes in his work The Path of Law. So now we'll discuss the very meaning of realism as expounded in the 1930s. A group of legal scholars in United States of America, they themselves styled as realists, and the very idea of realism is an antithesis of idealism. So, accordingly, the realist jurists desired to be realistic at all costs, while it is not possible to classify them as a school. At best, it would be said to represent itself a movement, an attack wider than the number of its adherents. So, indeed, they don't agree in calling each other realist or call their craft as realism. So, the very meaning of realism, as we found by some scholars who termed it as, for scholars as Bingham, Douglas, Frank, wherein they speak of those realistic as Professor Cook prefers to speak them as a scientific approach to law. So, to Professor Cook, realism means a scientific approach to law, and George Clark speaks about it as a fact research mechanism, and Professor Corbin talks about that realism is what courts do, and also Professor Oliphant describes it as an objective method of studying law, and Professor John Dickinson speaks about realism as the skeptical movement, and finally the realistic do not claim any membership to any school. They neglect the legislative law and look upon law as genuine if it is judgment, and so they rejected all legal rules and all the legislative enacted statutes. To only them, law is the law that made by judges in their judgment and decision. So they tell us about order and coherence in the legal system as a illusion, and certainty of law as a myth. So there is no certainty in the law as according to the realistic school jurists. So Professor Jerome Frank and Professor Lebelin Penley seems to mean that for any particular lay person, as is by Frank, the law with respect to any particular set of facts is a decision of a court with respect to those facts so far as that decision affects that particular person. So also a similar view is expressed by Professor Lebelin in his interesting work, and that is the Bramble Bush, where he opined that this doing of something about disputes, thus doing of it reasonably, is the business of law, and the people who have the doing in charge, whether they be judges or sheriffs or clerks or jailers or lawyers or officials of the law, what these officials do about disputes is, to my mind, the law itself. So, according to both Professor Jerome Frank and Professor Lebelin, they consider law as functional and as the day-to-day work and proceedings in courts, and the very judgment delivered by the judges and the officials, the lawyers who are associated in the process of decision making and the judgment itself it is law as they enunciated in their work so Professor Llewellyn in his interesting work, The Bramble Bush, he expressed the similar view. So now we'll discuss certain important features of realistic school or realistic movement. So there are five important features of the American realistic school. So of the realistic movement, the first one is uncertainty of law. So the realistic most striking feature of them is that they place upon uncertainty of law as a series of single decisions. Frank rightly remarks the physicists indeed have just announced the principle of uncertainty or interminacy, where a high degree of quantitative exactness is possible. If there can be nothing like complete definiteness in natural sciences, it is surely absurd to accept to realize when approximates certainty and predictability in law, dealing as it does with the vagaries of complicated human adjustment. So, in this way, they raised a revolutionary approach against the idealistic school of jurisprudence, the philosophical or natural law school, or against the historical school of jurisprudence. So, also, now we'll go to discuss another important feature, that is, they gave importance on emotion rather than logic. So, the second important feature of the realist school is its attack on the use of formal logic in law, which they term medieval scholasticism. According to them, the judge in deciding a case reaches his decision on emotive rather than on logical grounds. So, in this way, also, they raised a revolt against the analytical budgetism or the legal budgetism as developed by Jeremy Bentham and propounded by his disciple John Austin and carried out by the Austrian jurist Hans Kelsen as pure theory of law, but it was rejected by both the American realist school, also by the Scandinavian realist school. So, another important feature of the realist school is they gave stress and importance on behaviorism. So, the third important feature of realist school is the great weight they place on modern psychology with strong leading towards behaviorism. And the fourth important feature is what judges decide, that is law. So the fourth feature of the realist school is the attack they have made on the value of legal terminology, for according to them, these terms are a convenient method of hiding uncertainty of law. So Also, finally, another and most important feature is that evaluation of law in terms of its legal effects. So, finally, they really stress on evaluation of any part of law in terms of its effects and an insistence on the worthwhileness of trying to find these effects. So, in that context, we will discuss two important followers and propounder of American realistic school after Justice Gray and Justice Holmes. Justice Gray laid the foundation of the American realism or realistic school in his work The Nature and Sources of Law, and Justice Holmes carried out the work of realism in his work The Path of Law. So, Professor Carl Lebelin laid down certain important traces as professor of jurisprudence at Columbia University. According to him, there are basic common points on which all realists seem to agree. So he says a juristic inquiry must proceed on the basis of that law is in constant state of flux. That means it is constant changing. So also that law is a means to social end. So also that society whose ends law is a means is in a state of even faster flux within the law. And also he divorces between the very concept of ease and odd as we found in the judicial approach of studying law in the analytical school of jurisprudence founded by Bentham and John Austin, that as Professor Lebelin held that for the purpose of these inquiries, the jurist should look merely at what courts and officials and citizens do without reference to what they ought to do. There should be a temporary divorce of the is and ought for the purpose of the study of law. So also the importance given by Professor Lebelin is that the jurist inquiry must regard with suspicion in the assumption that legal rules as they are formally enunciated or inscribed in books represent what the courts and people are actually doing. So, what courts do and the very suspicion of the legal rules as developed by the analytical jurist and as it was developed through legislative enactment to which they made their suspicion as these are not the exact laws as we mean. So law as according to Carl Lebelin, it is the very suspicion of the legal rules laid down by the analytical jurist and also developed through statute by the legislature. So he laid emphasis on the actual effects that law creates. That is exactly the domain of studying law, that the realist must regard with equal suspicion to the assumption that rules of law formally enunciated actually do produce the decisions which purpose to be based on them. And finally, every part of law is to be valued in terms of its actual effects rather than in terms of the symmetry of its traditional rules, those rules which were developed by the natural or philosophical school of jurisprudence or by the historical school of jurisprudence, and finally by the analytical positivist school of Bentham, Austin, and Hans Kelsen. So, accordingly, he suggested that Professor Carl Levlin, led the focal point of legal research, as according to him should be shifted from the study of rules to the observance of the real behavior of law officials, particularly the judges. More attention, therefore, has to be given to judicial traditions on which court decisions rest. And now we'll go to another important follower and propounder of American realist school is Jerome Frank. And Frank, in his work Law and the Modern Mind, he enunciated that it calls law as the basic myth. So all legal concepts, according to Frank, is considered as basic myths. So the idea that law is continuous, uniform, certain, and invariable is a basic myth. So, according to Jerome Frank, the illusion of certainty of law is a basic myth to conceal the unwelcome fact of uncertainty of law. Thus, basic myth assumes that law is certain as a perfect body of rules and principles, and the task of the judge is merely to discover the appropriate principle and its application to the facts. Frank questions the basic myth that judges do not make law, they only discover it. So, that is the main emphasis of Jerome Frank, that judges, they do not make law, they only discover it. And he rejected outrightly this very legal myth, which he considered as the basic myth. Is the basic legal myth that he attacks, that the law is completely settled and definite form, and according to him, law consists of decisions of the judges in court of law. To most people, legal norms direct the judgment, whereas to Frank, not the legal norm, but judgment itself is the law. So he considered all legal rules as basic myth. So he invented the basic myth theory, and according to him, only judges do make law, and law consists of all those decisions delivered by the judges. So judgment itself is law, as it was propounded by Sir Jerome Frank, who was one of the propounder of American realistic school. So, to Frank, not the legal norm, but judgment itself is the law. Also, we consider all the legal concepts and those legal premises as myths, that rules are impersonal, unaffected by human emotions and behavior. However, Frank asserts emotion and behavior are key factors in understanding the judicial process. So, the key factors for understanding judicial process is the very emotions and behavior of the judges, lawyers, and law officers, and those persons who are involved in the very judicial process. Their emotions and behaviors are the key factors in laying down the very foundation stone of law, and it would be a better approach in understanding judicial process and what exactly law means. So he emphasized that it is a study of law in action and the courtroom, and not the laboratory. A library should be the laboratory. So according to him, it is an important element where he stressed that it was Jerome Frank who wants us to study the law that is in action and that is in courtrooms. So according to him, the courtroom, not the library, should be our laboratory to experimenting and enunciating exactly what law means, and to them as regarding Justice Gray and Justice Holmes, and to Professor Carl Lebland and Professor Jerome Frank, law is functional, and it is an antithesis of idealism, and there should be an scientific approach to study law, and it is based on social facts, the research, and what courts do, that is law, and there must be an objective method. So as they doubt and suspects about the legal rules and the legal orders as established, and those legal concepts developed, and it grew out of the statutes and by the legislature, all they doubt and suspect, so that it is called as rule skeptic movement of the realistic school. So in the very word of Professor Frank, we could say that even though it is rule skeptic, and once Professor Frank becomes the judge to the bench of a federal appellate court. He concentrated his attention from the rule aspect of the law to the scrutiny of the fact finding process in the trial courts. Thus, from a rule skeptic, Frank turned to be fact skeptic. So, in trial court, he worked for fact finding. So, Frank declared constituted the key factor in the administration of justice. With unrelenting jest, he probed into innumerable sources of error which may enter into a determination of facts by a trial court. So, we found the very origin and development of the American realistic school by Justice Gray in his work The Nature and Sources of Law, and it was further carried out by Justice Holmes in his work The Path of Law. So also we discussed some important features of the realistic school of jurisprudence, and the very important exponent after Justice Gray and Justice Holmes are Professor Carl Ledwin and Professor Jerome Frank. So, Jerome Frank, in his work Law and the Modern Mind, he considered all legal concepts and legal notions and those rules developed out of the statute made by the legislatures, and all legal notions and concepts as basic myths. So only law means those judges make in their decisions. That is exactly law. So to him, judgment itself is the law, and the judgment is made on the basis of emotion and behavior of the officials and judges, such as when the lawyers who were associated. So, emotions and behaviors are the key factors in understanding the judicial process, and that is law. So, he emphasized on of studied law in action, and the very action, according to him, is always in the courtroom, not in the library. So, the laboratory to study law, what exactly law means, it would be the very ground from where one can find the correct answer to what is law. That is the courtroom, not the library, as it is enunciated by Professor Jerome Frank. And when he became a judge in the federal trial court, he shifted his attention from rule skeptic to fact skeptic. So, we have completed the American realistic school in this lecture. In our upcoming lecture, we would like to discuss the Scandinavian realistic school or the Scandinavian realism.